Chriswell is here, our installment of Martial Law. This radio program intended to be for informational purposes only. The information does not constitute legal advice. The law constantly changes. The information may not be complete or correct, depending on the date and your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations. Because of these differences, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. Marshall Chriswell certainly is one of those. Good morning.
Good morning.
It's good to have you with us here today. So, we've been talking a lot lately about probate law, about estates and all of those things. What are some of the questions that you get as an attorney that would address some of those topics? I know that there are people out there that just don't know how to formulate the question.
Sure. Yeah. And, as we've talked about on this program, that the initial consultation with an attorney is really important. And that's what that consultation really consists of is, getting that advice, gaining a basic understanding from the attorney of what the lay of the land is with respect to the law and what the procedure is, moving forward with whatever kind of a matter you're handling. Mm-hmm. Now, with when you're talking about an instance where someone has passed away and you're thinking, okay, do we need to see an attorney and open a probate estate? There are so many questions that people have. And it's also, of course, usually an emotional time. There's a grieving process going on as well. So I really take a lot of care and spend some time in those consultations, to really try to answer as many of those questions as I can. One of the first kind of threshold questions that comes up whenever I'm meeting with someone who's lost a loved one, they say, well, do we need to do anything? Do we need to open a probate estate, or do we, is there anything that we actually have to do legally? And the answer to that question really depends on the facts. It depends on what kinds of assets did the person own when they passed away. Mm-hmm. There are in Pennsylvania, we recognize that there are two different types of assets when someone is no longer here with us. There are probate assets and there are non-probate assets. And so we've got to sift through all that. But usually some legal action is going to be required.
Yeah. Okay. I would guess it would be a much different experience, let's put it that way, the second time somebody has to go through this than the first time. The first time there's probably a lot of confusion about even the terminology.
Absolutely. I mean, you're dealing with, things like, okay, am I going to be an executor, an administrator, a personal representative? You get those kinds of things. People, and, folks, I think what we tend to do now, whenever in kind of modern life, when we're faced with an uncertain situation, we usually go online, right? And start to research a little bit. And then you see all this vocabulary, terminology starts being thrown at you. And of course, if you're online, you've got laws from all different jurisdictions that you're looking at, and which may or may not apply to you. And you can get confused really, really quickly. Mm-hmm. So that's something that we try to do is just cut through that confusion and try to define as many of those terms and answer as many of the questions as possible. I think another question, and this is a big one, almost every consultation that I have for opening an estate, and someone's there and they say, well, I've got Dad's will here and he names me as his executor. And I know we need to, from what you've told me, we need to open a probate estate. The next question usually is, hey, am I personally liable as an executor for any of Dad's bills, medical expenses, funeral expenses, long-term care, those kinds of things? Just financially, is the executor going to be personally liable? And that's a common question, and the answer is no. The answer is, no, you're not. You're not personally liable. Only the creditors of the estate can only collect from the assets of the estate, and we run into lots of probate estates where during the course of administration we realize that the bills are greater than what the assets of the estate are, and in that situation it's not the executor's personal responsibility to pay those bills, just to make sure that the process is followed properly.
one of the things that I would guess, and this is just me speculating, is a big question for folks is the disposition of real estate, homes and grounds, because there are very specific rules that apply here. Is that the case? Do you get a lot of questions about that?
You do. Real estate is obviously, one of most estates, most estates are going to contain at least one parcel of real estate. Okay, most folks at least own their home. And it's tricky. Sometimes in a will, the person has has willed that a parcel of real estate to a particular person, to a child or someone else. And it says, okay, my residence and the contents of my residence are going to my daughter, Susie. And then we know, okay, as long as there are enough assets in the estate to pay the debts, then Susie's going to receive the home. But there are, of course, other situations where it's more general, and the will might say, my entire estate divided between my 4 children equally. Well, what if 2 or 3 of those children want the family home? And how do we resolve those kinds of disputes? And of course, the other thing with real estate is it can be very expensive to maintain during the administration of the estate. So there's got to be enough liquid cash in the estate to pay taxes and utilities and the things, maintenance that you need to for the upkeep of the property during the estate administration, which sometimes can be prolonged, can take a little while. So that's going back to the planning process. Whenever I meet with somebody to do an estate plan, one of the things I'm looking at is, okay, if you passed away today, where would there be enough cash in the estate to administer the estate? Is there are the assets held in forms that it would be more difficult to get cash to do that? So there are all those considerations.
Something else that might come better in the planning stages, or at least be less complicated in the planning stages, is access to accounts after someone dies. If there's not a specific plan in place that gives the descendants the right to access accounts, that can be a pretty tangled up procedure, can't it?
The problems that you run into, number one, if someone is ill, and often it's just a final illness, but they're still alive, it's very difficult to access accounts unless you have a power of attorney. Okay, so you definitely, as part of any good estate plan, you want to have that in place. Once someone passes, the executor appointed in the will, once they're sworn in as the executor and the estate is opened, they then have the access. They then have the ability to access those accounts. But the problem we run into sometimes is not knowing where the accounts are. There's no comprehensive list anywhere that where the person has said, okay, here's a list of all the banks that I use, the retirement accounts, the insurance policies that I have, the things that make it much easier on the executor.
All right, we actually have a caller this morning that has a question for you, so let's ask her. Go ahead, ask your question.
Hi, my in-laws are in their 80s. My father-in-law is 83 and my mother-in-law is 80. And they've recently told us that they have recently remortgaged their house, and it's for 30 years. And of course, they probably won't live to, be able to pay that off. Is that legal for a bank to give that type of a loan to somebody at that age?
Well, that's up to the bank. If the person applying for the mortgage has the sufficient income and credit history, they can get a loan. Of course, the bank does take into account the age of the person and what's likely coming down the road. But sure, a bank can issue that mortgage, and then when your in-laws, when the couple have both passed away, the bank is going to be looking for that mortgage, obviously, to be satisfied by either the person inheriting the property or from a sale of the property.
Okay. If the children do not want the property, if it's willed to them and they don't want it, do they have to take it?
No, there's no requirement. There's something, and there are several ways to do this, and you really should contact an attorney, if and when this situation arises. But you can disclaim an inheritance. You can say, well, I know that, I know mom and dad left me the house or what it may be, but I really don't want to take that on. So you can disclaim an inheritance. Yes.
Oh, okay. All right. Thank you.
Welcome. Have a good day.
You too.
That's pretty good questions, huh?
Yeah, really good.
Yeah. And those are the sorts of things that that consultation, that initial consultation, would be all about. And while we're talking today about after someone dies, it really does point out the planning process before someone passes away makes that process so much simpler.
Yeah, a comprehensive estate plan really addresses a lot of these issues. Like I said, even down to, okay, what do these assets look like, and how are we going to make it as easy as we can on the executor, the beneficiaries, when the time comes, so that, I mentioned having enough cash in the estate. If you don't do that, you have an executor, beneficiaries who say, well, we want to administer the estate, but there's not enough money. Sometimes they have to end up loaning the estate money. So your kids are there, okay, we're each going to put in $10,000 to cover expenses and hope we get it back at the end.
Yeah.
You don't want that situation. You want to make it easy on them.
Yeah, absolutely. So. All right. Well, we're out of time in this segment, but we do have a chance for you to tell folks how it is that they can learn more about your services and how they can contact you and maybe start this process now.
Yeah, sure. You can call me at 724-465-5826. Stop by the Atrium Building in downtown Indiana or go online to westernpalawyer.com.
Thank you, sir.
Thanks, Todd.
It is the voice